The fiduciary that you choose under a durable power of attorney is called an attorney in fact. That attorney in fact has that original durable power of attorney. They can go to the bank and they can withdraw your account. Yes, sir?
Who decides that? Who decides that you can't make a decision?
There's different ways that, thank you for the question. So the question was, when can the durable power of attorney be used because you can no longer make decisions? We work with the primary care provider and they produce what's called a medical certificate if someone's incapacitated. In another instance, Christine could use my durable power of attorney. Let's say I was out of the country and my financial advisor said, well, look at the Dow Jones fell today 1,000 points. And my financial advisor calls and says, you may want to move some money because whatever it might be, and I'm in Europe. What a great place to go. And I call Christine, I'm like, Christine, can you do me a favor? Just run and do my signature under the power of attorney. So that's the other way a power of attorney could be used. Yes, but I can still make my decisions and she can slip into my shoes and act for it. If I'm incapacitated, we need proof from a physician that someone's incapacitated, which is a medical certificate that's issued by the primary care provider.
And that can be forced on the person? That can be forced on the person?
Well, it wouldn't be. They usually do think they're perfectly capable, right? No one ever wants to give up control, right? But when they signed that durable power of attorney, it was explained to them what it does. Doesn't mean that they still like it at this point in time. However, if a physician tells us that they don't have the capacity to make decisions for their own good, then we can use the attorney in fact to take care of that. Good? So again, that's why it's important to look at your fiduciaries. Some people will ask me, well, who should I choose? And I said, well, it's definitely your decision for any of these fiduciaries that we're going to talk about today. But you want to make sure that you're choosing people that you trust, people that know what's going on in your life perhaps, or whether it's your children or a sibling or, whoever it might be. But it's also that you have to have good communication with them. Because if you don't tell them what you want, they don't know. If you don't tell your 4 children that you don't want to be kept alive in the event you have no brain activity, and we usually hear that as machines, which would be extraordinary measures, then you need to tell your children that, because you can give what's called a living will declaration within your healthcare proxy. Your healthcare proxy, you appoint an agent in order to speak for you. And then you have a successor agent in the event that agent can't perform their duty. So if your agent, your oldest child, says, nope, mom wrote right here, she doesn't want to be kept alive in the event she has no brain activity. She doesn't want to be kept alive on machines. And one of your other siblings says, nope, mom told me different. Now we have the black and white paper that tells us what your wishes were, okay? One of the things, our goals, we sit down with you and we ask you what your goals are. And we figure out what documents we need in order to accomplish those goals. But you also have to have a conversation with your family about anything that's an emotional decision. Because what I explain to people is all these documents that we are creating for you, I call them the Saturday night documents because they're always needed in a case of emergency, usually, right? And guess what? We're all still human, doesn't matter. And everyone has human emotions that arise when it's time of stress, especially family stress, right? So all those emotions come up. Who feels like they weren't treated as good as the other one? Or who feels like a little resentful about something? Or, the older sister that's always been the control freak. So you have to make sure, your job is to make sure all of the information that you have in your head of what you want gets down on paper, okay? So the healthcare proxy is during your lifetime, just like the durable power of attorney, and it's with respect to medical decisions. If you don't have the ability to decide what you want, there are some I always say nurses, when we deal with nurses, they know the benefits of dialysis. However, they also know what it does to the rest of your body. So a lot of them will say, I don't want dialysis. There are a couple of different religions that don't allow blood transfusions. So some people will write in there, I do not wish to have a blood transfusion. So if you lose your capacity, your agent knows when they're speaking to the physicians at the hospital or the long-term care that you do not wish to desire to have these particular services done or procedures done. Now, that's the healthcare proxy. The most form is that bright pink form. Has anyone seen that before? Yep. So the most form is signed in conjunction with the patient's primary care provider, because the primary care provider is the one who has the medical opinion or the diagnosis of the person and has decided that it's time for a most form. And these are end-of-life decisions. Do you wish to be resuscitated? Do you wish to have a feeding tube? Do you wish to be intubated? And you fill it out when you have your capacity, and then that's on file, your medical file. You know, if you're with Brigham and Women's, then, you know, now the way the portals and the networks work, it'll be at all the hospitals that you're at. Okay, so that isn't something that we take care of because I'm not a doctor, and we don't have the authority to sign those documents and have them prepared. But we do the healthcare proxies. In addition to the healthcare proxies, it's also important to have what's called a HIPAA authorization, which is our quickie 2-page form. So if you have to deal with someone for insurance or paying a bill or getting records or moving x-rays from one facility to the next, it's a nice little form because sometimes information's only as good as who's getting it on the other end. It's a nice little form that will help you accomplish what you're trying to do. Any questions on those two documents? Does everybody have those, and are they up to date? No? Oh, I don't like the no's. So talking about up to date, on those two documents, both the medical institutions and the financial institutions, if you're using the durable power of attorney, don't like to see them if they're older than 5 years old. There's no law on that. There's nothing written. It's just a part of the industry. And if you think about it, if you walk into Walpole Cooperative Bank and you try to withdraw Aunt Lisa's savings account, and it's 15 years old for a power of attorney, their antenna is going to go off because they have liability. So they like to see the durable powers of attorney no more than 5 years old, which I understand. Now, also, what's important for you to update your documents is that there are laws that change. For instance, the durable power of attorney that we used to be 4 or 5 pages. Now it's 11 because there have been statutory law that's passed or case law. And most particularly, we want everything to include HIPAA language because, as you know, even with a husband and wife, you cannot gain medical information without authority under a HIPAA authorization. Okay? So think about those forms. One of your homework items is going to be when you go home, pull your documents out, see how old they are, and also see who your fiduciaries are. Make sure you still want that person to speak for you after you're gone or if you're incapacitated, or maybe that person has passed on. So make sure all of your documents are up to date with respect to that. Now, the other thing that we like, yes. Let me come over.
Thank you.
So everyone can hear you.
I have a question about how you explained the POA when you were suggesting that if you were out of the country, Christine could do this for you. Does she have to be registered as a POA? Does somebody have to acknowledge that?
So the question is, where does the POA get the authority to act for you as an attorney in fact? The actual document, as soon as it is signed, notarized, and witnessed, has all the power. So I tell my clients, always maintain that original document. We will also give you a couple of extras for copies. You show them the original, you pull it back, and then give them a copy. Because once you lose that original, that's it. And if that person has lost their capacity, they can't sign another one because the notary is not able to notarize their signature and take their acknowledgement if they've lost their capacity. So that's why your documents need to all be kept in a safe spot. Okay?
You mentioned one term in there, sound like mulching. It mulch like leaves, mulching together in leaves?
Springs on your mind, huh? No, most. MOLST. Linda, what is that for? Massachusetts? I know, I put Linda on the spot. It's an acronym for a name, for a form. MOLST. You're welcome. It's bright, bright pink, like the woman's shirt in the back row right there. It's that pink. You can't miss it. So any other questions with the durable power of attorney or healthcare proxy? Let's talk about gifting for a little bit. So part of elder law is that in the event you have to go to the state and ask for eligibility to become eligible for Mass Health Services, which is to go to a 24-hour care facility, you may have to spend down. Everyone's heard that term before, right? Spend down. Because you can only have $2,000 in an account and a $1,500 burial account to become eligible to receive services from the state through Mass Health, which means services means they'll pay for your services. So you have to become eligible. How do you become eligible when you're getting ready to move into a nursing home? You need to have your durable power of attorney work on all this. And it's like another job. You have a huge application. There's a lot of information that you have to gain from Mass Health. You have to give them 5 years worth of accounts, checking, savings, all the money, and see where everything went. Well, how do most of us get down to only having $2,000 in our name? Some people will spend down. One of the things that a power that your attorney, in fact, is given in the durable power of attorney is the ability of gifting. Okay? So let's talk about gifting for a little bit. Gifting is a federal law, the gift tax. It comes under the federal umbrella. In the year 2022, you can gift $16,000 to a person without incurring a gift tax. Sounds weird, right? If it's not your spouse, because spouses can give money back and forth to each other without incurring a gift tax, you can give $16,000 in cash, check, or by way of an automobile that's worth $16,000 to a person. The IRS code says if you give more than that, then they want to know about it. Now, they want to know about everything that you gift because once you hit the federal threshold, which is now in the 12 million mark, which I don't know about you guys, but I won't be hitting that, then you have to file what's called a gift tax return. When does this come into play? Some people will gift their home to their children. And if you live in Walpole right now, the equity in your home right now is probably the most it's ever been since you've owned the property. So if you're gifting the property over to your child, what will happen is you need to report that gift to the IRS. Okay? Now, if you lose capacity, you would need your attorney, in fact, to take care of that for you. But unless you gift up to over $12 million, you don't have to worry about paying a tax. Yes?
What if you give the house to your child? Would that still be a gifting?
It's a gift because no consideration was given back to you.
If you leave it to them, yeah?
Nope, that's different. So, you want to ask that again?
Yeah, if you leave it to them.
Okay, so you're not alive anymore then, right?
No, before you die, you want to leave that house to them.
Yes, and then they don't get the house until after your death?
Yeah.
Then that's not a gift. Then they are a beneficiary of your estate. So I do tell people it might be better for you to just leave it to the kids in the will rather than doing it during lifetime. Yep. And the other thing about giving a house away before you're gone is if you give the house to your children and you're living in that house is now an asset of your child, obviously, but that also means that their creditors can come after that house too. So that's one thing that you have to be careful about. Oh, sure. Thank you.
In order to reduce your money down, if I put money into a revocable or an irrevocable trust, does that reduce my income, my money down, my assets?
One of them will.
Which one?
I think you already know the answer to this question, but thank you for bringing it up. So we're going to talk about the different trusts that are available. And revocable versus irrevocable. Revocable, sometimes they call it a living trust too, in case you watch something on TV. But in Massachusetts, we just call it a revocable trust. So it's the same thing. Accomplishes the same thing, but it might have a different name. There's two levels to a trust. There's the ownership of the trust. Some of you may have your house in a trust. At the Registry of Deeds, either the trust or a trustee certificate was recorded as evidence of the trust, and that's who the owner is. John Smith, as trustee of the John Smith 2018 trust. The second level to the trust is the equitable interest, okay? The equitable interest is the person that owns it, the person that has the equity, the person that can take a mortgage on the house if they want to, if there's equity in it, and they can use that money, can do whatever they want. They can put a new roof on, they can go on a nice trip, they can do whatever they want with the money. That is called a revocable trust. You can amend it, you can change it, you can revoke it. You own it, you use your own social security number for anything that's in it, any money or anything like that. An irrevocable trust is when, let's use the house as an example, you take your house and you move it into an irrevocable trust. It's a gift because I'm alive and I'm not going to charge the trust for it. So it's a gift. I gift it over to the irrevocable trust. When I gift it, I lose dominion and control. So that's where you use it as a spend down. You take the asset out of your estate and you've lost control. In Massachusetts, we have a 5-year look-back period. I know you've heard that as well. Why do we have a 5-year look-back period? Well, you know, every good law has a con against it, right? Because at some point, someone was moving their property into an irrevocable trust in order to skirt a creditor. So now the state says, if you want to go to a nursing home and not use your house as a countable asset when you fill out that big application, then you had to have lost dominion and control of your house more than 60 months ago, more than 5 years ago. Back to what we were talking about, estate planning. We have to plan for these kind of things. Does that make sense? Answers your question? Okay. Yeah, I'm going to go.
The look back, don't only think of it as your house, even small amounts. I can remember when my mom, I was just about to put her on Medicaid because we were at that point, and she had gifted her grandchildren, I'll say $2,000 each for their graduation. And you know, they came back to me and said, you're going to have to pay that back because it was a 5. So don't only think of the big stuff when you're thinking about that, because even if it's a small amount, they'll come back after you. Because I was shocked when he said I would have to pay it, not even her. So just warning.
That's absolutely correct. So I noted to you that when you do file for requesting eligibility for Mass Health Services, you have to list out all of the assets, and if you have a checking, savings, CD, whatever type of financial institution account it is, if it's an investment account, whatever it might be, you have to give them at least 5 years worth of statements because they're going to track to see what you've done with your money. That's what they did. They saw that checks were written for $2,000 within the 5-year period, so they call it back, okay? And then she became ineligible for as long as that period of that money will pay the nursing home.
She didn't make it that far, but that's, I went through all the paperwork.
You did a lot of work.
But yeah, so just beware, it's not only the big things, it can be.
We have a question here.
Yes. You said something about the $1,500 for burial. Is that a prepaid plan or that's just money like a life insurance plan?
Well, we can't really bury anyone for $1,500 anymore, but unfortunately, it's not going up with inflation. So I'd say that'd probably be the luncheon, the mercy meal, maybe. No, it would be in a regular account at like Walpole Cooperative Bank, and you label it burial account. So it's for incidentals, part of a burial. But that's a great point. I recommend everyone to prepay their funeral services. So when I first started estate planning, which was 25 years ago, most everyone in this area, because of where we live, you know, they're having a wake, a funeral, a church service, a burial at a cemetery. Fast forward now, I would say 8 out of 10 people are being cremated. They want their ashes strewn on the marginal way up in Maine. You know, they don't want a wake. They don't want a funeral. They want a celebration of life party. That's the way it's going now. If you have not the usual intentions for your burial, you need to have a burial letter. We have a burial letter, and it is addressed to the personal representative of the estate. We're trying to avoid fighting, family fighting. I don't do divorce and stuff like that, so that won't help me anyway. The burial letter sets forth to your personal representative, who is the person, the fiduciary that you appoint under your will. We'll talk about that in a little bit, who's basically in charge. Now, just so that everyone knows, a decedent's body is the property of the family, the next of kin. Okay, so that's important to always know. Also, because if you don't have any children and your spouse is deceased and you haven't talked to your sister in 72 years, whatever it is, because you were fighting over a teacup, if your sister is your next of kin, she actually owns your body upon your date of death. It's an asset of hers. And she has the right, unless you've written it out and unless you've made plans, to bury you the way that she wants to.
The cheapest way.
Probably. Not unless she's getting money, right? The cheapest way, she said. Let me go this way. I'm going to grab her first. She was up first.
If you have this burial letter and you prepay for your funeral, what happens to that if the funeral home that you paid goes out of business?
Yep. There's an insurance plan that the funeral homes have to have for any prepayment of money that they take. When they take money in advance, they hold it what's called escrow. And those funds, if you go into it, you'll see all the paperwork that shows that they are, it's kind of like a bank, is FDIC insured. They have to have insurance so that someone will always be serviced.
So if it does close, does the money come back to the family, the estate, or does it get?
I'm going to tell you, I've never dealt with that. I have not dealt with a funeral home that has gone out of business and we're tracking prepayment of funeral expenses. I would tend to say that the money doesn't go back to the family because if it was being held for a service to be performed, there must be a way that it goes to another funeral home, probably at the recommendation of the family, in order to get the services for those funds. Thank you. Linda?
As long as they're raising everybody else's money, I still have a burning question about when you set up your Medicaid, you have to declare all your assets and you can only have $2,000. in the bank, so to speak, in your account. Is there any movement to increase that amount? Because I'm going to bother the politicians about that one.
You're a busy lady and bothering the politicians. Linda's very good at trying to get what she wants and what this community needs. Linda's question was the eligibility for $2,000 of only having $2,000 in a $1,500 burial account. Obviously, there's more involved in this too, like what's a countable asset, what's not a countable asset. It depends if you're an individual or a spouse. Is a healthy spouse at home? There's a lot more to this, but this is just the foundation that we're talking to. Linda asked whether or not there's any talk, and we do a lot of reading because that's what we do as lawyers. We always have to keep learning. I have not heard about that $2,000 going up. The only thing that I'll occasionally read about is the look back period being extended further than 5 years. Yeah. And that's been floating around for a little bit. So, we'll see what happens. I'm going to grab the lady in the back first. But, we like to keep everyone informed of any law changes also. Hi there.
Okay. I made arrangements with the Tufts Medical School that I'm donating my body. And then after I'm dead, of course, and so if I'm accepted, they will just take care of everything.
You burial?
Yeah.
Yeah, that's it.
And they will get in touch with a funeral home to transport my body, and then they will use it for 2 years and then cremate it and return the remains.
To your family?
Yeah. So I recommend that. You'll help science, you'll help the medical students, and it doesn't cost anything.
So I'll repeat that for everyone so they could hear it. This lovely lady, she has decided to donate her body to science, which is fabulous because this is how our med students learn is on cadavers. So she's Tufts Medical, correct? Tufts University Medical School, and they will provide everything. They will obtain her body directly from the funeral home and bring it for science research. And what they will also do is pay for the cremation and then return her ashes to her family. So there's another option that I might be hearing soon too. And I think anatomical gift, yes. And that's like when we have an organ donor on our driver's license. If you're in a car accident and you're healthy, and I've heard of people getting eyes, and never mind just organs. Like there's so many things that can be donated. So, make sure that you're an organ donor as well.
I have a life insurance policy through my company, and it's I 10 grand, whatever it is. Now, if you go to prepay your burial, you cannot use that life insurance policy. You have to pay it out of your own cash, and then that'll be reimbursed to the family.
So the question is, if you don't have the money, the funds in your pocket to go prepay a funeral expenses, how else could you do it? So some people that have life insurance policies, they can assign the life insurance policy, the beneficiary, to the funeral home. So when you go to the funeral home and ask them about prepaying, ask them if they will allow you to assign a life insurance policy to them. They'll do it. They'll take it. That's a great question. Thank you.
I'm a little confused still. You mean if right now you can be buried for say $7,000-8,000 minimum? If you pay the funeral home that and you live 10 years from now, the expense then could be $20,000 given inflation. So they will still they'll still bury you for $8,000.
So you can go get locked in right now at Walpole Center. You're right. Absolutely. Another benefit.
Because they've invested that money for 10 years. They've invested that money for the 10 years.
Right, but most people usually have cash to pay up front, and you're absolutely right. They invest those funds, so they get the money from the investment. Yeah. Any other questions before we move on to something else? Okay, so we covered the durable power of attorney and the healthcare proxy. The next thing that we want to talk about are the documents that are utilized upon your date of death. So, your will. Your will is the foundation of your estate plan. And the will, what it does for you is it gives us direction as to where we're going. Again, it speaks for you. The will accomplishes a few different things. So the first one is it tells us who your family is. So if you have someone that you're estranged with and they're named as a family member, we know that we need to find them, okay? We're going to talk about probate court in a little bit, and that's why that's important. It's also going to state where you're tangible, everything you can see, feel, touch, the tables, the chairs, where all that's going to go. Your artwork, your coin collection, baseball card collection, although they're not as valuable as they used to be, where that's going to go. Then it states, if you're using a trust, which I highly recommend, all the rest, residue, and remainder pours over to your trust. Okay, your trust is going to be your own little family company, and we're going to try to get everything into that trust. So we want to fund it. The other thing that your will takes care of is naming your personal representative. The personal representative formerly was called the executor or the executrix. That's the fiduciary that you've appointed to speak for you upon your date of death. They're in charge of marshaling all the assets, which means gathering all the assets, paying all the bills, paying the funeral home, getting everything together. Then they take everything and do a distribution through the trust. Not everybody needs a trust, but we can talk about that too if you have questions. But let's just say the distribution is through your will, and you have 3 adult children, and they're all competent, and they're all alive. Reasons why we would want a trust if that wasn't true. And there'll just be a distribution upon your date of death, okay? So your personal representative takes the will to the probate court. So we're in Walpole, so we're in Norfolk County, so we're going to go to the Norfolk County Probate Court in Canton. The will gets delivered to the probate court with the petition for either a formal or an informal proceeding. The difference is usually if there's real estate or something else that makes it a formal. And then the court goes through the process to make sure all of your heirs at law, bloodline heirs, or any other beneficiaries within your will have been notified of your death. We're also going to do a publication of a citation, you know, in the back of the newspaper, if anybody gets the newspaper anymore. Those are publications telling the world that someone's going to be appointed personal representative of the estate. If you don't agree with this and you want to contest that appointment, that you need to give your objection by a certain date. Once that date goes by, the person's appointed, and no one's contested, the person's appointed personal representative of the estate. Now, they're the ones that literally have slipped into your shoes. They take care of everything, close all your accounts. If you have a home, sell your home, take the proceeds, and then divide it between those 3 competent children. Okay? So that's how that works. Does anyone have any questions on a will? No? Everybody's got one, right? Oh, here we go.
My question is, if you have multiple children, how many should you
Who do you appoint?
Yes.
Okay. Great question. Some people walk in and they know exactly who they want, and some people have a hard time. Multiple children, you might give them different roles. A personal representative, a trustee under the trust, perhaps the attorney in fact. Another one could be a healthcare agent for you. The way that I see it is that you want to have the person that's most responsible to carry on these duties. And it doesn't have to be a person that happens to be in finance to be your attorney in fact. It doesn't have to be a nurse to be your healthcare agent. It has to be someone that, one, listens to you and to your wishes, because if they didn't, it's a breach of their fiduciary duty, and two, that can help to accomplish the goals that you want. And I'm going to say that they're a good listener for us. We work in a cooperative manner with all of the fiduciaries, and everyone is so kind and polite, and we give them checklists and we give them direction, because we're all getting to the same goal, which is the goal that you have. So when you are having an issue as to who to name, I'll give you a little sidetrack note of what I like to see. Normally, when we have two spouses, they're each other's personal representatives under their will, okay? So the first one to pass, the surviving spouse acts for one. Then we need a successor. The successor could be a child. It could be a niece, a nephew, a friend, whatever it might be. Obviously, it needs to be someone that's in a position that can perform this duty this year, 5 years, 10, 15 years down the road. I don't mind co-personal representatives there. If they work cohesively, that's great. I like co-trustees too, because then we have a checks and balance between two people. Maybe one of your children is savvy with finance, and your other child is very organized and can get things done and resourceful. They'd make great co-trustees. Where I don't like the co's, and I'll tell you why I don't like them, is under the durable power of attorney, where you appoint attorney in fact, and where you appoint a healthcare agent. If you have two people working together under those documents and as those fiduciaries, and they disagree, if they disagree, these documents, we don't have any resolution within these documents. There are no black and white referee language in there. So when they disagree, we end up in court. So I prefer, for the sake of you being helped appropriately, is that you only choose one person to be your attorney in fact, and you have a successor, and then you have one person as your healthcare agent, and then you have a successor. I'll do whatever you want, but that's my advice. Okay? We have a question? That's okay. Say it, because someone could have the same question.
Okay. I recently lost my husband, and I updated my will. I have two sons. They're 50-50 beneficiaries, but I named one as power of attorney and the other as my health care proxy. Is that what you're talking about? Yes. Oh, okay. Yeah. I did it right.
What happens if you don't have a will? What happens if you don't have a will?
So if you do not have a will in Massachusetts, that means that you died intestate. If you die testate, then you have a will. If you don't have a will, two things. Your closest blood lineal heir has the first right to be appointed your personal representative. Okay, whether it's your spouse or your child or a grandchild. You know, we go through like the tree of life. That's what we call it when we were in law school. Your closest heir is your spouse. If your spouse isn't there, then you go up to your parents. If your parents aren't alive, then you go out to your children. If your children aren't alive, then you go to the grandchildren. Okay? So your closest lineal blood heir has the right to be the personal representative. So that's your fiduciary. Then what happens with everything? Then it gets distributed, if you have a house, then it gets just sold and the money gets distributed according to all those heirs that are around you and where they land. If it's your spouse and you have no children from a prior relationship, your spouse is going to get all of it. So that's how that works. So this is why we want a will, foremost, so that you can appoint that person that you really want to be in charge. Maybe you don't want your husband to be in charge. Maybe he has already lost his capacity. So you want one of your children or maybe one of your siblings to be the personal representative. Or perhaps you have a child who has fallen on hard times and they could be addicted to something. and you prefer not to give them 1 full quarter of the value of your estate. Maybe you want it to go into a trust for them or something like that. Or you have a special needs child that if they get money through your estate, it could actually dissolve their right to get services from the state. So this is why we need to look at the whole scenario, everything going on under the umbrella to determine what we're going to do. That was a great question. Thank you for that. Any follow-up? No. This table's got a lot going on.
Because we can't remember. So this linear line, if there is no will, this linear line, and the first person that would be asked says, I don't want that, I don't want to do that.
Okay.
Who's the next one to be asked?
Whoever would be the next person
In line. Okay.
Yes. No, it doesn't go by age. It goes by lineage, which is the closest person to you in your bloodline.
So
They're the person that has.
5 kids and
Yeah, look at the room.
Well, they could decide between them. So if you
Not
want
automatically the
one
oldest.
rather than all 5, then you need to have it written in your will.
but if there's no will,
Then it would be 5 of them arguing as to who would be appointed.
okay.
I'm not picking on them. I'm just using it as a hypothetical. So that's the question, that if you have multiple people in that lineage spot to be personal representative, who gets picked? Well, they're all in the same spot. This gentleman has 5 kids. They're all landing in the same lineal line. And then the 5 of them would have to determine who wanted to be, and what if 2 of them wanted to be? So great reason to have a will. Yes, sir.
I was always under the understanding that if there was no will, it automatically went to probate.
2 different things. But that's a great segue, thank you, because we were going to talk about probate and what probate is. Probate is one of the courts in the jurisdiction where we bring your will to be probated, or if you don't have a will, that we want an intestate estate for the personal representative to be appointed, because they have jurisdiction, and this is the long story short, over dead people's things that have nowhere to go when they die. So what things have somewhere to go when we die? I own my house with my husband and wife, tenants by the entirety, with joint survivorship, which means if I predecease him, my undivided 50% interest goes to him automatically. Okay? But then guess what we did? He owns it individually. When he dies, it has nowhere to go. Yeah. Right? Do that again.
Whoa. Whoa.
Whoa was right, because we just created a probate asset. So when we look under the umbrella to see everything you have, we want that house to be in a trust. We want the house to be in a trust so that we don't create an asset, a probate asset. So the hypothetical is, I died first, he's still alive, but then what if he loses his marbles? Now he has no capacity. But guess what we did? We moved it into a trust. So the trustee immediately steps up and can take power and control of everything for the benefit of the beneficiaries. So whether he's dead or he's alive. So some people get afraid of trust, but don't be. It's really the best thing that you can do for the people that survive you and the people that are going to take care of things for you. Question?
Yes, instead of putting it into a trust now, what is the harm if you were to predecease him and then he puts it into a trust immediately? Would that work?
That's a great hypothetical. And then we go back to, we don't have a crystal ball. What if when I die, he's already lost it? He had too many concussions from playing baseball. So you never know. Yeah. Too much grief? I don't know. He might be clicking his heels. I don't know. So that, it's a lot. I'm not going to lie. Everything I'm telling you is a lot. But we try to minimize it as best possible so that you understand what's going on. We're starting to get close to 2 o'clock here. So there is something else let's get one more question.
I just have a question about life estates. What's good about them and bad about them? Because I have no children, and if my husband dies, that means I own the house, but then do I want to leave it to my niece and nephew? And if they forbid me to sell the house, I have to ask their permission. So basically, would I be better off putting it into a trust?
Great question. Thank you. So the question was with you got a couple things going on in there, but let's start off with life estates. So just like we talked about the tenancy by the entirety between myself and my husband, when my tenancy died with me, it went to him. And that's exactly what a life estate does. A life estate says, I'm going to live in this house until I die. And guess what? A life estate has value. I could actually buy your life estate and live there until you die. And I bring that up because people ask about that when they're trying to become eligible for Mass Health Services. They think because they only have a life estate, it doesn't have value. But guess what? Your life has value. And your possessory interest in property has value. Okay, so keep that in mind if you ever come up with that. So her question was, she wants to leave the house, hypothetical, to her niece and nephew. If she puts them on the deed now as remainder people, because when you have a life estate, the life estate again is gone, right? It's no longer in existence upon your date of death. The remainder people are the people that get the full possessory value of the property. They jump up and now they're the owners. But if she wants to sell the property, if she wants to put a mortgage on the property because she needs a new roof, she wants to get a home equity line, she has to get them to sign off to it. So her follow-up question was, should I put it in a trust? And my answer is yes. Yep. See, I love trusts. And people are afraid of them, but as long as they're drafted correctly and all of your assets are taken into consideration, it'll work nice and smooth for you. Okay? So I recommend that you do that because, like you said, then you still have power, you have dominion and control over the entire home. If you wanted to sell it and move to Florida because you hate the winters, you could do it. Thank you. Another question from this table.
The situation that you're just talking about. You die, your husband, no children, whatever. Yep. And he decides to put everything in a trust. Yes. Okay? Yes. Now, when he does that, yep, does the 5-year look back start from that point then, or is it still?
What kind of trust is he putting it into? An irrevocable trust. The 5-year look back period begins the date the house is conveyed by deed, recorded at the Registry of Deeds, into that irrevocable trust. That's the clock. So if we are in a position where we don't need the equity from our home anymore, you know, we've already got rid of the kids and paid for all their college, and, you know, they took all the money out of our pockets, and we want to move it into an irrevocable trust, we always want to do it sooner than later, because that is when the clock starts ticking. That's a great question. So let's go back to trust for a little bit. Any other questions on wills? Everybody seems to be good on wills. Wills are actually pretty simple, but that's the foundation to get you out of intestacy, okay? To get out of the statutory law. One more over here.
What if you have property and you have a little bit of money and you have no children, you have, and no husband, you have nieces and nephews and they're all in the will, but you also do not have a long-term health care. Now, I'm anticipating that if I need to go in, that everything will be sold for my health care, which I want, by the way. And then I'll go into, because I want to be able to choose, I want to go someplace nice, let's put it that way. And so I want the money to do that. So would putting everything in a trust negate that? How would that work?
What kind of trust are we using?
I don't know. I mean,
We would leave it in a revocable trust because you want your money and you want to use it the way you want to use it, right? So we need to leave it in revocable so that you still have dominion and control over the equity.
what would be the advantage to the trust versus just a will in my situation, being alone and just wanting to sell everything?
Avoid probate. Okay, so you pay a little bit of money up front. The question was, what's the advantage of using a trust as opposed to leaving the house in her name individually? You pay a little bit of money up front to create the trust, to draft the deed, to draft the trustee certificate, and the crazy recording fees that the registry's charging now. But what it does is you've now avoided a court proceeding. You've now avoided probate court opening a docket. It's incredibly time consuming right now because they're very behind. And it's not always expensive. Let me say that. And that is a little bit of a misconception. If you're organized now during your lifetime, it could be really easy on the back end. We've got a system that we use. We help people get organized while they're alive. So then upon the back end, it's a little bit easier. It can get expensive when people contest. If a child contests the will that they were left out of the will, but there's language, not for lack of love and affection, but Susie Q's not getting anything from my estate because she's already been provided for. And maybe she was. Maybe you paid for her college and you gave her $200,000 to buy a house. Well, if Susie Q still thinks she didn't get enough, she could contest the will. So then we have litigation. That's when it turns into litigation in the probate court. Yes.
I don't know him.
She threw me out. No, my question would be, we have done all of this.
Yes, excellent.
But it's well beyond the 5 years. Now, to redo it, it should be redone, right?
No, you don't have to. Are you done? Yeah. The question was, if you have an old estate plan, does it need to be redone? No. No, the first thing that we do is we look at your documents to make sure that they're all up to date with respect to any laws, most particularly tax laws. We didn't get into too much of estate taxes, but that's the biggest thing that we want to make sure. If you have a taxable estate, which means between the two of you, if you've more than $2 million, you're going to be thumbs down. Good, but not so much. The second to die, the surviving spouse's estate will be taxed. So we do try to minimize that within the revocable trust. So the question was, if you have an old estate, do we recommend that it be rewritten? Nope. If you have good documents that have everything that I need to see in it, if you have good documents that have clear and concise language. Some attorneys just like to use their legalese all over the place. If it's clear and concise language and it's not confusing, then we'll most certainly use them. And if your will needs to be updated, we can update it by way of a codicil. If you have a trust and your successor trustee has passed, or they're ill and you want to name someone else, we can write you an amendment to the trust. So that's how we take care of those documents. If your durable power of attorney, healthcare proxy, and HIPAA authorization are older than 5 years, we're going to rip them up and we're going to write new ones. So it can be very simple. Okay? One more question over here. Get my steps in.
Yes, you are. Are any of these documents, like healthcare proxy, compatible with other states?
That's an excellent question because people do move. The question is whether or not any of the documents that are drafted in Massachusetts are accepted in other states. Will they accept it in times of an emergency? Yes, because it's something in writing. If you move to Arizona, I suggest that you have your estate plan reviewed, and also if they suggest that you write new documents, you do that. All of these documents are drafted according to statutory law, according to Massachusetts statutory law. So I'll give you an example. My father had a Massachusetts will, and then he became a Floridian resident. So when he passed, I filed his even as much as I told him to do a new one. Where's my friend? I'm the youngest girl in an Italian family. Do you think my father listened to me? No. So when he passed, I filed his Massachusetts will in Florida. Well, Florida doesn't use what's called a self-proving affidavit. So I had to go through a couple of hoops to explain to them what a self-proving affidavit is. I'll tell you what it is. In Massachusetts, when you sign a will, we have to have an affidavit that 2 witnesses were before you and they said it's your free act and deed, willingly and voluntarily. You're not under duress signing this, and also that you have capacity. Capacity upstairs and you're over the age of 18. Florida doesn't do that. We also have, we like to do a notary as well on the same affidavit. So when that was presented for the judge, for my mother to be appointed personal representative, they were like, whoa, what's this? So I had to write a legal memorandum for it. Had it been easier if he wrote his wills down there? Probably. But they still accepted it. Just makes it a little bit more complicated. Yes, in the back. 1 second.
So, when you make an appointment to speak with you for personal reasons, just make an appointment, but do you give a checklist of what you need to bring ahead of time? You send that through email or something? We can. Okay, thank you.
Thank you. So we have what's called an estate planning questionnaire. Like I said, it's gets longer each year as something comes up with my clients that I feel it's important for someone to be notified about. You know what's big right now is passwords, logins and passwords, because everyone's doing everything online and we're all getting paper statements. So, you know, it was great when we could just do a password and that was it, but now they're all asking us to do secondary I can't say that word, authentication, and also update it every 3 months. You know, so it's getting a little tiresome. But that's why you want to make sure either your spouse or your personal representative knows all of your online accounts that you have. If you have a like a Morgan Stanley account and you only, or a Fidelity account, you only access it online, make sure your loved one or whoever's going to take over for you has the login to get in, or the original durable power of attorney to call them and get access to that account. So the question was on the estate plans, we now have that in there about any virtual accounts. Even if you have Facebook or whatever it might be, if you want them to know that, or maybe you don't want them to know it, but make sure that that information is in there. So the estate planning questionnaire will go through pretty much everything we're talking about right now. Gathering your assets to find out what the value of your assets are for estate taxes, how your assets are held individually or joint or already in a trust, so that we can talk about probate. And then we get into your fiduciaries, the people that you appoint in order to speak for you when you can't speak. Okay? So we just have a couple other things over here. When you look at asset management, everyone just did their taxes, right? Their 1040 individual taxes. This is a good time for you to start looking at all of your accounts, because you had to get everything together for your accountant anyway. So look at how you're holding your accounts. See if you have anything that's held individually, because we don't want to do that. We want to make sure there's either a joint tenant on there or you put it into a trust. Okay, or the other thing too is beneficiaries. If you have a CD, if you have a life insurance policy, make sure all your beneficiary forms are filled out correctly. Okay? Anyone else have any questions? Yes, yeah.
How much does it cost?
How much does it cost? I've been waiting for that. So, when we send you the estate planning questionnaire, we make an assessment as to what we think you need. Then we talk to you what your goals are, and then we can give you an estimate. And the reason why I can't give an estimate right now is because I don't know what I'm doing. Right? I don't know what I'm going to do for you. As soon as I know what I'm going to do, I can tell you. And my office, we do everything on a flat fee basis. It's a flat fee basis for all the phone calls, all the funding, the drafting of the documents, the signing of the documents. It's one flat rate. So you know everything that's going to happen. And I have clients call me 5 years later, questions, and we answer them for them.
Do you have any comment about these marital bypass trusts?
Yes, that's the marital AB trust to assist with the estate tax consequence, federal and Massachusetts, upon the surviving spouse's death to try to minimize. And one comment that I do have to say is that Massachusetts used to piggyback the federal. It could be called the unified credit. It could be called the threshold. But it's basically the amount of money you can die with without paying a tax. For federal, it's in the 12 millions, like the gift tax we talked about. That's a federal tax. Then we have a Massachusetts tax. Massachusetts used to piggyback the federal. Hey, that sounds great, right? Well, then they said, ooh, wait a minute, we're missing out on taxes. So they passed a statutory law that is $1 million. If you die with more than $1 million, you're going to pay taxes from bottom dollar. Well, from 40, they give you the first 40,000 for free. It's a graduated tax, but the lowest it will be is 16%. So that's like $160,000 on $1 million. So the marital AB trust, the marital trust, the special marital trust, they all do the same thing. They have different names. It's to help alleviate the consequence of taxes upon the second to die. So that's why when you're filling out your estate planning questionnaire, we're asking you for your assets, not because we're being nosy, but because we want to try to help you alleviate that burden for your kids or whoever you're leaving things to. So we can utilize it with a marital trust, but then maybe you have a life insurance policy that we could use to pay taxes. Or some people are like, I don't really care, I'm already dead, so I don't care who's paying the taxes. So everyone's different. Everyone has different situations. Some people are dead set on getting stuff to their kids. Some people are like, I already paid for them to go to college and do everything. And that's great. But I just need to know what your goals are. Then we can go from there. Okay? Any other questions today? That's it? All right. Well, hopefully, thank you. Thank you very much. Thank you for coming. It's very nice to see everyone. It's nice to see everyone back at the center. If you have any questions, feel free to reach out to us. But otherwise, I appreciate your time today. Have a great afternoon.